Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. I'm Kirsten Howe, and today I'm going to do another little episode in my mini-series that I'm calling affectionately Estate Plan Misses, and we're kind of talking about miscommunications, misapplications, mistakes, just kind of the things that we have learned over the years doing many estate plans and also doing many trust administrations. The things that aren't necessarily legal advice, but maybe sort of more practical advice. And hopefully you can learn from some of the misses that we've seen happen. Today, what I want to talk about is the idea of making money available after you've passed away in a simple and efficient and ideally fast way. And this can come up when we're talking about, say, a funeral or a burial or a cremation needs to be paid for. And some of the ways that we leave money to those who survive us take more time than really what we might have in a situation like that. So the first thing I would say is it is possible to prepay for funerals and burials and cremations and all of that. You can do that. So I'm talking about primarily people who haven't done that. And there are a lot of reasons why you don't necessarily want to prepay that. But if that's not the case or that is not a good solution for you, the ways that your survivors access your cash depends on how you left it. And so, we want our clients who need to have a trust to have their assets in their trust. And so they would have, say, their checking account would be owned by their trust. And then when they die, the successor trustee comes along and says, hey, I'm now the trustee of this trust, so I get access to that account, all of which is true. The problem is that can't happen until a death certificate is obtained. And typically we're seeing, and it varies by county, but we're seeing death certificates take probably about 2 or 3 weeks. So that may not be the solution. Another way that you can leave your assets behind is you could just have your checking account in your own name, and that's going to be even worse than leaving it in your trust because nobody can access anything in your own name for at least 40 days after your death. So we have the death certificate problem, plus we have the law which says we have to wait 40 days. So what are some of the alternatives that our clients have used that we've seen work? And they all come with caveats because now we're getting into things that I would not recommend except as a strategy for making cash readily available. So an alternative would be make a person, like your successor trustee, the person that you trust to do the right thing for you, make them a pay on death beneficiary on an account. That also requires a death certificate. So again, we're talking about 2 or 3 weeks, not ideal. What might actually work is make that person that you trust, your successor trustee, make them a co-owner of your checking account. While you're alive, you actually take them to the bank with you and have them added onto your account. Now, there are all kinds of problems with that. We've got multiple episodes where we've touched on that topic. You're exposing your assets to their problems. But if you've determined that this is the way to go, that will work. If they are a co-owner on the account, they don't need to show a death certificate to be able to use the account. They'll be able to right away, write checks or do whatever they need to do, pull cash out of that account to pay for what needs to be paid for. So that's one possibility. The other problems with it, if you've got, let's say you've made one of your children your trustee and you've added that child to your account and you have more than one child, when you add someone to an account and then you die, legally that account belongs to the other owner. It's a joint tenancy and there's a right of survivorship and that other owner legally is the owner. When I've seen families use this process, most of the time, the vast majority of the time, the child understands that that's not my money, that's my mom's money, and I'm going to put it in my mom's trust, and I'm going to use it only for trust and, death-related expenses. It's not my money. I think it's important to understand, to have that conversation with the child that you're adding onto your account. And I would also say maybe don't make that a $100,000 account, because they're not going to need that much money. They're going to need what they need to do the immediate work after your death before they get access to all your other assets. And I would also say, if you do that, it's a good idea when you have more than one child or more than one beneficiary, it's a good idea to leave behind a written statement that you did this. I added this child to my account. The only reason I did it is to make cash readily available. It was not my intention that this one child, inherit that entire account. It's just communication. So that's probably the easiest way to make sure that there is cash available right away after you pass away, if that's what you're concerned about. The only other thing is, have actual cash available. I don't like that idea. I don't think it's prudent to have a bunch of cash lying around in your house. Anybody could find it and take it. Your house could burn down, but it is an option. And I've had clients discuss that with me. So you have to do what's best for you and your family. The bottom line here is that probably having a co-owner on a small joint account is the way to make cash readily available immediately after your death. And along with that, you want to make sure that everybody knows what's going on, what the expectation is, so that there aren't any hurt feelings, no surprises, nobody taking advantage of their unique position. Okay, I hope this was helpful. And I am very grateful that you're here. You're listening all these years that we've been doing this podcast. We appreciate your support. Like it, subscribe to it. That would be great. Thank you so much. And I look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.